Well, hello, everybody, and welcome. I am so glad that you were able to make it today. We are at the Orange County Association of Realtors, and my name is Kevin Burke, and there's my telephone number, there is my email address. And so I got that JD after my name, and so JD stands for juvenile delinquent, as most of you know. But essentially, I've got a Juris Doctorate. I've got a law degree. I do not practice law. I'm not interested. It's a lot of work. But I do have kind of a heads up on a lot of things that will help you in your business. So I want to thank especially Elsie and the Orange County Association of Realtors who allowed me to put this on today, and I very much appreciate them. And of course, as you all know, on Monday um, I was at the association, the Fountain Valley office, doing a presentation on how to hold a safe and successful open house. And that was very well attended. We had a great time. And so hopefully you're able to make it for that. And then here we are today. Okay. So thank you all for being here. So let me see here. We're going to go, and this is going to go pretty quick. I've got literally 2 hours. And when I created this originally, I thought I had 3 hours. So I have 2 hours to do essentially a 3 hour presentation. But here's the deal. I don't want that to stop you from asking questions. Please interrupt me. I live to be able to help take care of some stuff. And so please let me know if you have any questions. I know that the association has triggered the ability to Q&A with me. Okay, so but I'll be looking at both the Q&A and the chat. But I don't want to miss a question that you might have. So sometimes I end up having to go backwards, but we'll just have to deal with that. So and of course, yes, this is being recorded, which is awesome, which means it'll go up. Orange County is kind enough to put me up on the internet and make it very official. So anyway, thank you to them today. Here are some credentials, I guess, that make me qualified to talk about what I talk about. So I have a broker's license. I am a broker associate in several states. And I have been in real estate for well over 46 years, doing a lot of the things that you're doing every day, and I continue to do those things myself. So I also teach attorneys continuing education, real property law, and try to make them better at what they do. And then I've taught, as you can see on the bottom of the screen, I've taught all these classes: principles, practice, legal aspects. I've never had a problem getting anybody to show up for my classes. I always had classes that were like, you have 35 people as a limit, and I ended up with 65 people. Thank you, Elizabeth. And so I always ended up with more people, and the school always had to give me like a pardon for having more students. So, I love to teach. I want you to do well. I really do. It's very important to me that you be a tremendous success. And again, I thank the Orange County for allowing me to have some feedback on that. So I am a realtor emeritus, which means I've just been in the business more than 40 years and full time, by the way. So, it's a good thing. I've also chaired everything that's out there. I think I call it the trifecta. I was the chair of risk management for California. I was the chair of legal affairs. And next year I'll be chair of professional standards. So, I must have missed the meeting where they asked for volunteers because they keep putting me in positions and as you all know, I'm apolitical. So, I don't get involved in all that. But again, my theme is risk management. My theme is do it the right way the first time. It'll save you till the end of days. Okay. So most all of my presentations may be found, and this is the YouTube link. So you just type in and then Burke Real Estate Consultants, Inc. And that will take you to YouTube, to my YouTube station. And I put things up there. I don't put it up there every day, but I do put things up there on a fairly regular basis. So that's my YouTube station. So also take a look, and I forgot to tell them on Monday about this, but I did a podcast with the Department of Real Estate, and it was legal matters and documentation in a real estate transaction. And again, the Department of Real Estate has been very good to me over the years. We fear two people in our careers. We fear the Department of Real Estate. We fear attorneys, and it's like, I'm not afraid of any of them. I think we work together well, and so, but please understand that you have certain rules that you have to follow, and we'll talk about those today. So again, if you have a question about anything, chat, Q&A, whatever. In fact, I'm looking here. I don't see the Q&As on my screen, so. Let me see, is there a separate Q&A thing? Yeah, there is. Okay, so I'm more likely to see chat, I guess, huh? Okay, so anyway, upcoming presentations. So, here we are today doing this class, but we are going to do it again next month. Similar, but I always come up with interesting things to add to it. So on the 14th of November, I'll be doing Navigating Change again. And again, it will be a Zoom call, giving people more of an opportunity to attend. Okay, so ongoing podcast for me, I do Coffee with Kevin every Wednesday evening at 4 p.m. Pacific Standard Time. And as a member of the Orange County Association of Realtors, I invite you to attend for free. Please come on in. Simple link. The short link is bit.ly/coffee with Kevin, and the coffee is with a K. And you are invited to come in there. I have attorneys lined up who will be speaking. I have physical inspectors. I have home warranty people. I have all kinds. I have the attorney for one of the natural hazard disclosure companies speaks on a regular basis. So you are more than welcome to come in. They speak, but they answer questions. And that's the beautiful part. I think you need to be learning as everything you can learn in real estate. And as I've always said, everything I know about real estate, I learned by my association with the association. So folks, I'm hoping you're taking advantage of the amazing opportunities that are given to you that will make it easier for you to do your business. Okay, so again, Orange County Association of Realtors. So Coffee with Kevin, free to you. We don't record that one, right? Because we want to be careful. We don't want to be. We're clearly very sensitive to antitrust and things like that. Okay, so there's the scan. There's the QR code for those of you who have a QR code reader. That will get you signed up for the class. Once you sign up, you're good for the rest of the year. Save the link. You're good for the rest of the year. I'll create a new link in January just so I can see how many people are really still coming to it. But again, free to you, no charge, and that's the way that is. Also, if you ask for it, OCAR will give you a copy of this presentation as well as the ancillary forms, probably not. But I'll be talking about some ancillary forms that go along with your buyer representation agreement. Our goal today is to help you be comfortable with the agreement, help you to ask questions, help you to lead to a path where the client is comfortable working with you. And then we'll go into the legal stuff. We'll go into the details of things where we have a lot of fun with that. And so again, please, we're going to be talking about things that appear to be legal. I am not a practicing attorney. I do a lot of trial work, mostly defending brokerage firms as an expert witness. Standard of care is my specialty. Agents' duties of inspection and disclosure, also my specialty. And so again, so keep that in mind, because if I can help you with any of those things, please reach out to me. Email is usually the best way to get a hold of me. Market conditions in San Diego County as well. So we're good so far. Let's keep it going. So conversation today is not intended as a substitute for the advice of your broker. And I think this is really important. You need to get your broker's advice. Even if I tell you something, it's not going to take the place of your broker. I'm never going to get in front of your broker, nor am I going to get in front of your attorney. So I want you to go to your source. Those are the people that have to defend you. I'm the one that sometimes people have to call. When sometimes we get ourselves into a bad situation, it doesn't necessarily mean we did something bad. It just means that somebody out there was angry. And so I had a conversation with a commissioner on, on Tuesday. It was just like, return their call, right? And so a lot of people are afraid to call their client back when they're upset about something, but it's certainly going to save you a lot of time and energy and a lot of grief if you just talk to your client, okay? All right, so please consult with them as appropriate. Our webinars are intended to be interactive. I do please ask you that if you have a question, please let me know. Again, chat, looks like chat I'm going to be able to see a lot easier, but if you put something in the Q&A, I'll find that eventually, but Q&A will be faster. Okay, so please utilize, and there I got the Q&A button. So, even though we've just talked about making it a chat. So we're going to talk about navigating change. So the buyer representation agreement, as you know, has been out now for a short while. And there's a Q&A. Okay, good. So Linda, hi Linda. Is this webinar going to cover the changes from the settlement that changes how I need to use the residential agreement and with commissions? Oh yeah, we're absolutely going to be talking about that. And we don't talk about commissions anymore, Linda. Good question. Now we call it compensation. And so I did a talk on Wednesday at the Coronado Association of Realtors, and we had to spin all the way into MLS rules and things like that. So we're not going to get into all of that today, but we are going to be talking about some of the things that happened. And as I told them in the class, the original lawsuit came out of Southern California and got thrown out of court. So we're talking about Sitzer Burnett. And so that they then took it to a friendlier, the plaintiffs took it to a friendlier environment where they could get a better response. And of course that worked. So now we're living with it. And so as a little bit of history, I'll tell you that back in 1991, and again, I've been doing this 46 years, but back in 1991, we made the decision that we would have, by default, we would have the seller pay the buyer's agent's commissions because it was usually the seller that had the money. And so that happened in 1991. And all we've really done now is reverse that and put it back on the seller pays the seller's agent, the buyer pays the buyer's agent. Does that make sense? And so we talk about compensation, but again, there's some distinct rules that we're going to talk about today that I think you're going to find very interesting. Okay. All right. So impact from a broker practitioner perspective, that's what I do. I have submitted this course, and as I told them the other day, I have been approved by the Department of Real Estate to teach it again. It's pretty much every 2 years you have to put it in for renewal. So this is not that course. I just want you to know that this is not the renewal course. This is not CE credit. I know that Orange County has me teaching those courses next year. So for right now, this is essentially the same course, but doesn't have all the same stuff. So ground rules. So by virtue of you having a real estate license in California, at least, the DRE allows you to explain the standard forms. And this is very, very important. So people say to me all the time, well, I don't want to give them legal advice. And I agree with you. You should not be giving them legal advice. But you do have the right by license to explain the forms, the standard forms. Now, standard forms are going to be those forms that we use that for most of us, the CAR forms. You don't want to create your own forms. If your broker wants to create forms and have the attorneys review it, then that's fine. But the CAR forms are usually fairly safe bet. So we have a form called a use of non-standard forms advisory. And so I'm going to take us over to that. And from time to time here, I'm going to pop into these other windows and show you some of these forms. So let me see here, get to the one here. So this is my, which one is this? This is my buyer representation form. So this is my use of non-standard forms advisory. And so I actually use this form a lot. And the reason I do is because I'm frequently getting in an counter offer situation, I'm getting somebody else's controlled business disclosure or something like that. Well, that is not a standard form. And so as a result, I can't explain to my buyer whether or not they should sign it. So I tell my buyer, I have the ability to explain standard forms, but not non-standard forms. And that's what this form is. This is CAR form NSF. So just a quick little rundown. We put this in all of our transactions. We have the client sign it so that they don't come back later on and say, well, I didn't know that you weren't allowed to explain that form to me. Okay. And by the way, here is the purchase agreement that I started with when I got my real estate license back in 1979. So the CAR standard form, it says right there, California Association of Realtors standard form, was the standard of practice, standard of care at that time. And you can see it said real estate purchase contract and receipt for deposit. Today it says real estate purchase agreement and joint escrow instructions, because that's what we did. We no longer took a check from the buyer, and we still do not take checks now for the last quite a few years. So we also did write the escrow instructions. So remember, your contract is escrow instructions. Okay. All right. So you notice how it's blank here in the middle. Paragraph number 1 is why we have 17 pages today. Okay, so we have 17 pages because we were writing our own language in here, and that became non-standard language because all kinds of crazy stuff was going in there. So that's what the form looks like. And as I said to you a minute ago, I will send you all this, or Elsie can send you all this. OCAR will give it to you. I've made it free. But look at the copyright date. It's in June of 1971. So it's funny because I talk a lot about these things. And the other day I had Frank Gabriel, who's really a neat broker, got his broker's license in 1963, and he sent me a whole bunch of his forms that were those forms at the time when he got his real estate license. And I just thought that's history in the making, right? So it's really good stuff. So that's my use of non-standard forms advisory. And then I just showed you the purchase agreement and receipt for deposit in 1979. And that's one of the reasons we have a 17-page purchase agreement today. And why, by the way, there are more than 250 ancillary forms in our library. So, it's interesting to see the morphos of these things. A lot of people are afraid of change. Obviously, I've had a lot of changes I've had to make over the years. I tell everybody I used to dye my hair gray so I would look very official, but now I don't have to do anything to it at all. It just automatically comes out gray, so it works out all right. All right, so I've always said, if you know the buyer representation agreement, then you know real estate, okay? And again, I have been teaching the buyer representation agreement since so for decades now, because I love the form. In our office, we require the form. You must have one, or we're just not going to pay you. And then, of course, then the law changed in August, making it so that we can't pay you if you don't have a buyer representation agreement with your buyer. We can't pay you. So that's kind of some big changes in our industry, and it's caused a lot of people, to start spinning around. So a written buyer representation agreement, it's not just a good idea, it's the law in California, and that's California Civil Code 2992. And so people think I wrote the law. I did not write the law. I have had input with it. I've given input to the Department of Real Estate on what I think it should say, and they are making some of those changes right now. And so, but for our purposes, it is the law. We must follow it. That's easy cheesy. Okay. All right. So, and DRE, they're currently wrangling with language in the statute as soon as practicable. So the NAR settlement, Linda, the NAR settlement said that you had to give it to the buyer, have it signed by the buyer before they wrote an offer, before you showed them property. And so DRE says, we're not comfortable with that necessarily, because we're not here to enforce the NAR rule. So the DRE said, we're going to struggle. We're going to define what as soon as practicable means. And so, and again, they've got tremendous help from the California Association of Realtors, which I think is wonderful. CAR has done a lot to try to protect us over the many, many years. Okay, all right. So remember, there are two parts to the agreement. There is buyer representation and there is broker compensation. Okay, so buyer representation is one thing, broker compensation is another thing. And when I get into the meat of the form, you're going to see why those two are critically important. Okay, easier to understand the concept if you differentiate between the two. So buyer representation, you need a written agreement with your buyer in order to call them your client. And so, by the way, and I'm brokered in other states, and so I can tell you I'm brokered in California, clearly, and I can tell you we've often been deceiving the person sitting next to us in the car by having them think that they were our client, but they really weren't. They were our customer. And so they became a client after we had a written agreement. Well, California just kind of looked the other way for many, many decades and said, well, we're gonna assume that you are that something's going to happen in the real estate transaction that will make the buyer the client. And so for sure, when you have a seller that has a listing agreement, now you have a client, right? And so same thing holds true with the buyer. You don't have a client until you have a written agreement. So the Department of Real Estate said, well, we're going to, there's different rules of law. There's ratification, there's justifiable reliance. There's all kinds of rules of law that can convert someone who's working with you in a real estate transaction into a client. And so it was kind of a stretch. I was not comfortable with it, but that's one of the reasons we made it a requirement in our office that you had to have one. So, but I don't think it's enough just to tell you to have one. I think it's important that you know how to present it, how to get it, why it's so important. And so for many decades where I was teaching this, people would say, well, I would never sign one. And I would say, well, why wouldn't you sign one? And they would say, well, I don't work that way. I want the client to be comfortable. And so I was constantly fighting with that. And again, same language, client versus customer. And then all of a sudden, the Department of Real Estate, realized that California, and when we created the statute, right? So the California Association of Realtors essentially created 2992, which was really a copy from the statute that said that if you're working with a seller, you had to have a listing agreement. The buyer representation agreement is a listing agreement. It's a listing agreement with the buyer. Okay. All right. So otherwise, they're only a customer. All right. Now I want to show you some interesting facts that I hope will make it really easy for you to explain your position, to explain, not just say, go ahead and sign it, everybody does, or whatever, but I'm going to show you some reasons why you really got to know what you're doing with this. So broker compensation is part number 2. You need a written agreement with your buyer in order to get paid. If you do not have a written agreement, you are not to be paid. And so again, being a broker in other states as well, I can tell you that in those states, the broker will not pay you without one. And so now in California, you've got the same thing. Finally, California kind of got into the 90s here. And so they said that you are not entitled to be paid unless you have a written agreement. Now I want to just step aside for a second. Technically speaking, it doesn't have to be a CAR BRBC form. Here's the issue. If your broker creates a form, and of course they've had it reviewed by the attorneys, then you follow your broker's advice. They have to defend you, right? But for you to go down to a stationery store and grab one, you are not qualified to explain that form because it is not a standard form. Does that make sense? So you have to have a written agreement. I think the easiest one to have is the BRBC, okay? And DRE requires it has to be in writing. They don't require the BRBC, but again, you put yourself in harm's way, and you don't have the user protection agreement, in case something goes wrong with your transaction, okay? So in fact, they always have required it. It's just that, they found ways around it because our practice in the industry was a little bit different. Is everybody okay with that? Again, chat, Q&A, whichever you want to do. Those words that I hate to hear, but I've always done it this way. I hate hearing that, and I'm so sorry because, again, if anybody should be mired in the past, it should be me, right? I've just been doing this a long time, but I've come to accept the fact that things are going to change, and so I need to be ready for that change, and these changes are beneficial for you. They're very helpful for you in your business. In the old days, we were paid as third-party beneficiaries. I want to show you something. One of my students did this. I want to show you this, that we were paid as third-party beneficiaries. That's a term of law. It's a TPB, right? So, and again, I teach attorneys real estate law. So that's how we got paid. We were a beneficiary, a TPB, of the listing agreement between the seller and the seller's agent. So the DRE said, okay, well, there is an agreement out there. We'll kind of stretch it so that it applies to you, even though it really didn't. And so Sitzer-Burnett came along, the Sitzer-Burnett case came along and said, nah, we're not going to, that you need to have a separate agreement, even though the reason it failed in California, that lawsuit failed in California was because California's forms are very clear. Like on the seller's listing agreement, it says on paragraph 3A, it says, here's the total commission. And then in 3D, it says, here's how much I'm paying out of the total commission, how much I'm paying the other broker. Okay. So out of that, well, Sitzer-Burnett said, again, it didn't work in California. That's why they had to go to another environment for that. But essentially what they had was, they wanted to keep the two separated. I'm a strong believer in that. I think that works really well for us as real estate agents. And as you get better and better at presenting it, I think you must have a buyer consultation agreement in all of your talks with your buyers. Don't just send them a form and say here. Now, I did train the DRE special investigators. I did a training for them on the buyer representation agreement, and essentially, this is the same thing. We were worried that you weren't going to explain the pre-printed language. But, I think after you get through this, remember, you must advise and counsel. That's your job. Okay. All right. So one of my former students created this representation of her understanding of the concept. So let me pull that up here really quick. And I want to show you, there's my one page. Let me see if I can get it here without too much. There we go. So this is one of my students did this. And I just thought that she did a brilliant job. And I told her at the time, I said, you're going to go on to become a really good broker. And so guess what? She did. She took the salesperson's test after she finished with my class, but she had created this during the class. And so on the left-hand side, we have how we kind of got paid, without the buyer representation agreement, right? It was a BRE at that time. And again, I haven't edited this. This is what she created. And we have that third party beneficiary relationship. And so she's far better than I am at Excel. You go to the right hand side, and this is what it looked like with the BRE. And that's true today, right? Listing agent to the seller, selling agent to the buyer. We've changed the names a little bit. Back in October of 18, we changed the agency disclosure, Civil Code 2079. We changed it to say seller's agent and buyer's agent because the listing agent and selling agent were just too confusing for people. So everybody good with that? I just think that she did a great job on that. In fact, she did such a great job, I made her the broker of my company. So, hey, what the heck? So that's why I am a broker associate of my own company with my name on it, because she probably knows more about real estate than most anybody I know. So she's done a really good job. She would just follow me around and listen to things I would talk about. Okay. All right. I'm going to turn off the phone here. Okay. So there you go, Linda. So I put her name up there. There's her name up in lights. Hi, Linda. Those old days are gone, right? Enter the Sitzer Burnett antitrust decision. And again, Linda, which Linda? I'm sorry, what was your last name, Linda? So Linda Ruiz. If you have a question, please stop me, okay? Those old days are gone. Enter Sitzer Burnett. It's an antitrust decision, okay? I disagree with the decision. I want you to know that. I do disagree with it. I'm sorry, I agree with the decision. I disagree with how they got there. I don't think they got there on a clean path. I think they got where we needed to be, but I don't think they got there from the right origins. And that's what everybody complains about. The real estate community complains about it, but I really don't complain because it got us what we needed. It was an expensive lesson. That's all. Okay. Remember what I said earlier, 1991, we had made it so that the sellers would pay through the seller's agent, the buyer's agent's commission. Okay. All right. So if you want more information on Sitzer Burnett, go to facts.realtor. There's a lot of really good stuff in there. And I've covered this frequently in the past. Not so much anymore because people have come to accept it. But in my coffee with Kevin on Wednesday night, again, which is free to you. So, it's interesting. We've got some very bright people in there and they ask a lot of really good questions. I never know what I'm going to get. But again, I'm happy to help you in any way that I can. I want you to do well. It is important to me that you do well. Because remember, if you look good, you make me look good. So I really do want you to look good. Okay. All right. As a result of that settlement, NAR promulgated rules that applied to all realtors. And so that would take effect 17 August of last year. So we've been over a year now. And for some of you, remember now that more than half of our licensees, more than half of the 414,000 licensees we have in the state of California, more than half of them have had a license less than 5 years. So some of you doesn't even know what it looked like back 20 years, 10 years, 15 years ago. And that may be good, right? So if you're newer, stay current, learn something new every day. People taught me things when I got my license, and I just feel like today I'm just paying that back. I really do. So, but those rules took effect again in August of last year. The settlement was quite some time before that, but it's the rule now, it's for sure. But remember that those rules did not apply to all licensees. The NAR rules only applied to the realtor members, okay, those agents that subscribe to a written code of ethics, okay. And again, as chair of professional standards next year, I like talking about the code of ethics. It's kind of cool, right? But the rules did not apply to people that just had a real estate license. So that's why we came back and we said in California, we're going to create a new set of rules, and that is we're going to make the NAR requirement apply for the most part, apply to even non-realtor licensees in California. Okay, so they were not subject to those rules. Not for the protections that the rules provide. So that rule that was created, the settlement that was created, made it so that there wouldn't be copycat lawsuits and things like that. And so it was a one-time deal. Lots of money got shelled out, but it was in exchange for a promise that wouldn't happen again. And so everything's been done. It's all ratified. That's just the way that it is. And so Carr quickly proposed and had passed legislation, made the rules. Okay, most of them, right? Remember, as soon as practicable versus before showing a property or writing an offer, apply to all California licensees. Now, remember, if you are a realtor member, which it's highly likely that you are subject to the NAR rule before the CAR rule, because the NAR rule is going to be tougher than the CAR or than the DRE rule. So for you, before you write an offer, before you show a property, whether physically or virtually, you have to have a buyer representation agreement. And it's kind of the point behind why we're here today. Okay. So it's sort of like leveling the playing field. All right. If you're not sure of the distinction between the two, what's the difference between a licensee versus a realtor licensee? And again, we talked about this 424,000 licensees, 185,000 of them are realtors, which means the balance of them are going to be just licensees who essentially don't subscribe to a code of ethics. We have a really good, I'm sorry, let me rephrase that, to the written code of ethics that NAR espouses. Okay. All right. So CAR has an excellent form that explains the distinction between the two. And so why it's beneficial to the realtor, to the public, to use a realtor. So you should be using this form in every transaction that you do. All right, we require it. And that's the realtor acknowledgement form. So let me pull that form up for you really quick. If you haven't seen it before, I love this form. It is awesome. So this is the realtor acknowledgement form. And I'm looking here. This is the one. Is this the current? Yes, this is the current one. So if you don't know the difference between a realtor and just a licensee, you might want to take a look at the form. I frequently have a conversation with my seller or with my buyer about the distinction between the two before I even show it to the client, right? And so, but ultimately I will show it to the client, and then I'm going to sign it in front of them, and then I'm going to ask them to sign it as well. And so most times I ever do that, they're fascinated by the concept between the two. And that checkbox is intentional. You can't uncheck that box. So we're representing that we are a realtor member, and we subscribe to that written code of ethics. Okay, everybody good with that? All right, I'm going to take us back here into the PowerPoint. And a realtor is held accountable to the written NAR code of ethics, and I'm very careful about how I say things. A non-realtor is not. It doesn't necessarily mean that the non-realtor is not ethical. It just means that they don't subscribe, and they don't hold themselves accountable to the written code of ethics by the National Association of Realtors. That's a huge thing. Folks, I'm going to tell you that is my number one selling point when I take a listing. I'll go in there, I'll start getting into all that, and then the customer will say, I had no idea it was all that complicated. It's like, well, it's really not complicated at all. I agree to be held bound by things I do and things that I say. And so some of these other people are not going to be bound by the same rules I'm bound by. And that's a fair statement. I didn't say they weren't ethical. I didn't say they didn't know what they were doing. I didn't say any of those kinds of things. But I said I'm held accountable to this, and I'm willing to be bound by that, and they aren't. So, again, it's all in the way you put it. Okay. So there are those that believe it gives the newer licensee realtor a distinct advantage. And I think that's true in most. In my office, we tend to train more new licensees than we do agents that have been around a long time. They get kind of used to how they're doing things. They get into, doing things a certain way. So prepare for your buyer consultation. All right. Yes, you need to have one. More so because some of you remember the day where the person would call you on the phone and say, "I want to see this property," and then you would say, "Well, okay, why don't you? Where are you?" "Well, I'm in front of the sign right now, in front of the property." And so we have the habit, and again, this goes to safety, but we have the habit of just dropping everything we were doing. We're cooking food for the kids, whatever, and we would drop everything that we were doing, and we would rush off to show them the property. First of all, that's incredibly dangerous, right? You don't know who you're going to meet. You don't know how many people are going to be there. You don't know whether they're a good guy or a bad guy, or good people or bad people. So it was very, very dangerous. I think, and again, I've been teaching this for a long time. I think you need to sit the buyer down and have a consultation with them about why it's important. You need to know things, right? So when you talk to your buyer, for sure you have in your buyer consultation, where do you want to live? What zip code? how many bedrooms, how many baths, how much do you want to spend. So you already have the makings of that buyer consultation. And I have buyer consultations I'll share with you. If you send me an email, don't send me an email that says, send me everything you talked about. Send me an email that says, send me this, and I will send you some buyer consultations I've gotten from some very big brokers. Okay. All right. You need to conduct your buyer representation, or your buyer presentation. It's an interview to find out what is important to your buyer. Okay. How will you know what to fill in on the blanks on the forms if you don't? So I want to cue Irene Young. I love Irene. Irene was one of my agents. I was management at the Rock People in Del Mar for quite a few years. And Irene was one of my agents. And Irene, and I finally, after 25 years, I called her on the phone and I said, Irene, I got to tell you something. I talk about you all the time. And she, Kevin, right? So, listen, I talk well about everybody, but Irene, she's special. So she would get the buyer at the window or whatever. She would always, always, always have the buyer meet her in the office. Okay, now I know a lot of us don't have offices anymore. We're going virtual, stuff like that. But she would always meet them in a public place, and she'd always sit down with them. And she had a what do you call it, a legal pad, and she would have this list of questions on it. And I'm going to recommend that you do this. This is really important. So she had a list of questions that she would talk to them about, and she would ask, and she would go from 1 to 2 to 3 to 4, and she would ask the people these questions. I would watch her up in the conference room, and I would start to feel bad because her questions would go about 2.5 hours. 2 hours and 45 minutes average. I would be knocking on the door. Would you like some coffee? Can I get you lunch? Things like that, because I felt, but listen, let me tell you something. No one ever ditched Irene on a transaction. Once you sat with her for 2.5 hours, and she knew everything you were looking for, because she actually asked the questions. Didn't tell anybody how great she was. She just sat down and just asked the questions. She was doing a lot of transactions, but she spent her time sitting in front of the customer, making them into a client so that she didn't waste their time or hers. Okay, so 2.5 hours, I get it. She's selling a lot of property. You want to be that person, okay? So that was Irene. I just love Irene. She's just a great lady. So, these are the kinds of people that you want to emulate in your career, all right? So let's discuss some of the common objections to signing a BRBC, signing a buyer representation agreement. So, so what do people want to know? They're like a seller. What does a seller want to know? How much are you going to get me, and how much are you going to charge me to get there? Those are the two questions they always, always have. And so the buyer today, the first question they're going to have is, how much are you going to charge me? And they're going to say that because, it's kind of a defensive strategy. Maybe I'll go see if I can find somebody to charge me less, or maybe I'll try to find somebody that doesn't have me sign an agreement. And remember what I said a minute ago, it is the law in California. So if they're able to find, you tell them, you say, hey, if somebody has you, if they're going to work with you without an agreement, then you understand that they're breaking the law. I don't know if you'd want to work with that kind of person. Okay. All right. So how much are you going to charge me? And so how long is it going to be for? And again, I did this talk in Coronado. You can have a buyer representation agreement for one day. You can have it for a weekend, right? I mean, you're holding houses open, and the buyer wants to look at the house, and you decide that it's a good strategy for you to have them sign a buyer representation agreement, and you can have it for just that weekend, because then you can talk to them about other properties and stuff. If you don't have an agreement, you're kind of restricted on what you can talk to them about. And so we're going to talk in this class about some of the forms that you should have in that conversation. Okay. So what if I want to play the field? I love it when they say that to me, right? I want to play the field. It's like, oh, okay, great. It's kind of like speed dating or whatever, right? But at the end of the day, I don't know. I have to make a decision whether I want to work with that person or not. It's kind of like my listing appointments. I go on a listing appointment wondering if I want the listing, not oh my God, I hope I get the listing. No. Do I want the listing? And so it's just an attitude problem that I have. But if somebody says to you, I want to play the field, and you can't convince them to sign a buyer representation agreement, even with you for one day, you've got a handful of places to show them. So even one day is okay, right? So, but get that agreement signed before you show them property. Okay. So if they want to play, and I've had this conversation, I have a business partner for 15 years, and she just couldn't get it in her head to get the buyer representation agreement signed. So, I told her, I said, well, why don't you just go to the beach? Right? If they're not going to sign the agreement, then why are you beating your head against the wall? And now, of course, it's the law. All right. Okay. What if I don't want to sign one with you? Well, now they're telling you that you haven't built that rapport with them yet. And you want to build rapport with the person that you're talking with because you don't want them to have second thoughts about things. And people do anyway after they sign agreements, but you're in control of that. I should say your broker is in control of that. Talk with your broker about what to do on that situation. But if they don't want to sign one with you and no way, no how, then I personally wouldn't work with them. I have other things to do, right? Okay. Don't be afraid of the question. They're going to ask it. They think that they're supposed to do that. I've had many a conversation with a customer who would ask me a question, and after a period of time, and again, folks, I'm telling you this with 46 years of experience. After a period of time, I realized they weren't really having a problem with what I was saying. It wasn't an objection, really. They just needed to back me up a little bit so they had time to process what I said a minute ago. And that's kind of important to realize that they're not fighting you on this. They're just trying to understand what it is that you just said. And so if you get that look in, the deer in the headlights look, you might want to slow down and just say to them, hey, you know what, let's talk about it. This is how it works. 13:40. Yeah, okay, good. I'm watching my time. I probably should set a timer. I'm going to give you all a break in about 15 minutes, if that's okay. All right. So I can set my timers. So they don't know what else to do. Your client doesn't know what. Many times it's really just a question. So present your value proposition. All right. Remember to distinguish yourself from the rest of the pack. I always did the top 10 things I'm going to do for you, and I would put it in writing because people are more likely to remember the things that you put in writing than they are things that you just tell them. Okay. Take notes from your buyer listing agreement. All right. So you go into your buyer listing agreement, look what the top 10 questions are, and just write them down. Okay. Prepare for the objections. So and so will charge me less. And my response has always been they probably should, right? Because they can't compete with me. They have to compete with me based on my price because they can't compete with me based on my service. And so when I say something like that, that just floors them, right? So that's a script, and you want to remember that, and you want to make it your own. You want to repeat it enough times that it sounds like it's coming out naturally. And I've done that before on listing appointments where I asked the seller, I said, how much did your previous agent that was unsuccessful in selling your property charge you? And they said, well, they did it for X. They did it for some other figure. And I said, wow, okay. So my immediate response was, well, that didn't sell it, did it? And then I stop and I pause and I wait for it to sink in. And then the seller looks at me and goes, okay, fine, you get your 25% commission, whatever the number is. Okay. All right. So good. So remember the old saying, you get what you pay for. I'm going to tell you to let them complete the sentence. So you get what and they will automatically say pay for. And once they do that, they own it, right? And so these are just scripting things that we do to make it so that the client understands, that we're in this together. Okay. All right. They're going to own it. That's an important concept. I hear the commission market is at whatever. I say X. Your response is, how do you know that? Okay. And sometimes somebody's sharing listing MLS printouts with them that just don't work, right? Because we don't put commissions in the MLS anymore, right? Remember, Linda, we do compensation. We don't put that in there. And most MLSs throughout the country have created fine schedules that are so significant. Like, for example, I think CRMLS, I think, is $2,400 for putting in, and there's really no oops kind of thing. I know Bright MLS, which is kind of the sister MLS on the East Coast for CRMLS, is like $2,800. So these are significant amounts of money. So we don't talk about commission anymore. We talk about compensation. So and so has a lot of listings, right? Or has a lot of buyer representation agreements. Your response is, I promised you personal service, right? Would you rather work with me or the agent, the seller's agent, or and it could also be another buyer's agent whose loyalty to you may be questionable or compromised. Okay. How are you going to handle this at your open house? And so this is kind of an important thing. And I talked about this on Monday, so I won't go too deep into it, but it's a good time to review that holding a successful open house that I did. So Mondays was not recorded, but I've done several others. They're available for you on the OCAR website. They're available for you on my YouTube website as well. Okay. And so OCAR's made me famous. They put me up on their website, which is really awesome. Okay. All right. So 3 things to remember. You want to do your forms library when you're creating things. You want to do templates. And I'm going to tell you why this is important, because these forms change. The BRBC is going to change again in December. Minor stuff. But if you're using templates, then you will have the updated version as it occurs, right? We will not change a transaction that you have in process. We won't do that, right? So if something changes, I would recommend that you not update the form, because they've already signed a different form, right? Unless we tell you that you have to update it. But for the most part, the changes that occur in December are going to be minor changes, but you all know we just published new forms a couple of was last week before, and we call that a soft publish, where we publish things and we try to tell you about it, but we don't do a good job of that. And so if you're using your templates, like for example, we just added a form to the RPA. It's the federal reporting requirement form, right? And so it's if you use the new RPA, it's included in there. If you have a template and you use the template to create a transaction, it's included in there. And so because you're a member here, I will make available to you, I will send you my template. If you send me an email requesting it, I will send you my buyer offer template, okay? All right, so send me an email. Don't send me something that says send me everything you talked about, because I'm not going to know what that is. So send me an email that says send me the buyer offer template. I will send you my template. I will even send you instructions on how to add it into your Zip Forms program. Okay, that's my specialty. I like doing that. All right. And finally, do not copy transactions, because here's the problem. When you copy a transaction, you are copying an old form. So if you're going to copy a transaction, okay to copy it, but then apply the template. Is everybody okay with that? Any questions so far? Okay. If you have a question, it's a good time to ask. This is live. So, but you apply your template to the new transaction that you've created, okay? So let's talk about the form itself. And we're going to go into a deep dive. So I think what I'm going to do is give you a break for a couple of minutes, because we are going to talk about the buyer representation agreement. I'm just going to nail it. So let's take 5 minutes, give you a break real quick, 5 minutes, and then we're going to come back here, and I'm going to go through the form line by line, and show you where the hot buttons are as we go. Okay. All right, everybody. Thank you so much. See you shortly. Okay. How am I doing? 5 minutes? Maybe a minute early. All right. I'll give you another minute, and then we're going to launch back into it again. And now we're going to get into the really good stuff. So I'm very excited about this. Linda, of course, is telling me I'm very loud, but I have that radio voice. And so I think as we go through this here today, I'm hoping that you'll ask me questions, because there's so many great things about this agreement that are going to just make it so easy for you. Good. Okay. So let me take another drink, a lot of water. Okay. Elsie, am I good? Start. I am going to go ahead and start. Okay, so, whoops, chat. Yes, good. Thank you so very much. And welcome back, everybody. And thank you for being here. I'm so glad we got through the non-legal stuff, I think, pretty well. But now we're going to get into the form. And so the Department of Real Estate has called me their forms expert. And I love the Department of Real Estate. I don't know where they came up with that, but I do enjoy the forms. And so let's talk a little bit about that. And so again, stop me if you have a question, because we have time. We can get this done in the next hour. So starting off, I've got the buyer representation and broker compensation agreement. Make sure you're using the current iteration of the form. Make sure you're using the current form. So this says 625. So I don't know if it can get much sooner than that, right? Now in December, when we change the form, and it'll be a couple minor little changes, it'll say 1225. Okay, so you always want to make sure you're using the current form. And one of the reasons, of course, is you have the user protection agreement. But the other reason is that when we change the forms, right, and we don't change them all the time, but when we do change them, we've changed them in response to legislation and litigation. Okay, so we've changed them in response to things that we have seen in the industry that have impacted. The laws will change, things like that. Okay, so that's pretty important. All right, so this form, just so you know, is non-exclusive, right? Non-exclusive means, they can sign 100 forms with different people if they want, but they're not obligated to you, right? Unless it is exclusive. And if it's exclusive, that means you agree to work with me, I agree to work with you exclusively. No, none of this play in the field kind of thing, none of this thing where you go on after. Now, some people are not comfortable with exclusive. Some agents, it's really the agent, right? But they're not comfortable with asking someone to sign an exclusive agreement. So if you're not comfortable with it, then start off with non-exclusive. Get used to what that means and how to explain that. I think you should be doing exclusive. That's just my way. But you definitely need to listen to your broker. Do what your broker tells you to do. But it's not, this is a non-exclusive agreement unless we check the box that says exclusive, and then we have an additional paragraph, number 15, towards the middle of the page that is going to explain to the client what it is that they've just agreed to do. And so if you don't have that initial, then it doesn't apply by contract. Okay. All right. Now, so date prepared, and we've talked about this before. Date prepared means this is the date that the document was created. And so for purposes of the recitals, as we call them, that is the reference date for all of the forms that come after that. Okay. All right. Now, so right to represent. Very simply, the right to represent says, I want the buyer's name. And so this is the secret to doing this right and to creating an enforceable agreement between the parties is, and of course you would want that, right, is that you have the right buyer. So if the buyer says to you, my name is, Bob Fields, for example. Well, there aren't a lot of legal names that say Bob. You want Robert or whatever their legal name is. And the secret to getting that is going to be a driver's license. We call it a DL in law enforcement, or a passport or something, because when they go to purchase the property, the title company is going to want their name as it is legally. And so you want your contract to be bound with these people legally. So you need to have their name. Okay. Now, you've got two types of persons. You've got either the natural person or the non-natural person. And so natural person is someone who bleeds when you prick them. A non-natural person is essentially everybody else. Now, since non-natural persons can't sign things because they're not natural persons, there's usually a natural person somewhere nearby who has signing authority. We call them the statutory agent for corporations, or they have a power of attorney. There's a lot of different things, but you would put the name of the buyer. How do they want their name to appear on title? Never say to them, how do you want to take title? Because that actually begets tax and legal advice. You never want to do that. You always want to say, how do you want your name to appear on title? Now, if they want to call themselves Mickey Mouse, I get it. Are they going to be able to show a driver's license that says Mickey Mouse? I mean, if they're paying cash, title doesn't care, right? So, but when you go to sell the property, you're going to have to prove that you're Mickey Mouse. Okay. So I've heard all these things and it's just like crazy stuff. Okay. All right. So grants. And so the agreement says we're going to grant and employ. So if you remember your listing agreement, and I'm looking to see, what is your email address? Okay. Let me see here. Answer. Type the answer. Okay. So let me type the answer for Julie, and it's going to be, and I'm going to have it at the end as well. So hopefully, and I don't know, this is probably one of the most common questions I get. So I probably should have typed it in there for you earlier. I can spell. I wish I could see .com. So Kevin at Burke Real Estate Consultants with an S.com. So now hopefully everybody can see that. If you want a copy of my templates, send, and again, be specific about which template, send me an email to my address. And I just put it in the chat or in the Q&A field. So send me an email, because if you leave it in here, I lose all these messages after we turn the program off. Okay. So, so please send me an email, Kevin at BurkeRealEstateConsultants.com. Everybody good with that? All right. And then again, I'll have it at the very end of the presentation as well, along with the QR codes again. Okay. So we talked about the buyer. All right. Now we're going to talk about grants. So grants and employees, the broker. So that's the broker for the company. So if you're with the red people, it would say the red people. If you were with, not the individual necessarily, unless your broker is the broker individually versus as an entity, as a DBA. So you put that name in there as well because you want those two to come together. You want that to be an enforceable agreement between the buyer and the buyer's broker. Okay, not you, the buyer's broker. All right. So again, the non-exclusive right, unless exclusive is checked and initialed, to represent the buyer in acquiring real property or a manufactured home for the representation period. There's a period of time we're going to do that. And again, you could do it for a day, you could do it for 2 days. Some people do it for 3 months, but we're going to talk in a second about how long you can't do it for. So let's talk about the terms of representation, the items, so our contractual terms of the agreement. So and then the rest of it, the reference paragraphs, are going to provide further explanation. And so, it's kind of interesting. This form is 5 pages. Buyers is advised to read all 5 pages. I have argued with CAR about that. I think it should say the buyer and the realtor is advised to read all 5 pages because sometimes we just don't read them, right? So it's like, I've had people say to me, well, when they said, well, I'd never signed one. And I say, well, have you ever read it? And the response is, well, no. And I said, well, why don't you read it? Because it's probably going to say some things that you wanted to say, right? Or it's easier to understand it. Thank you, Julie. It's easier to understand it if you've actually read it. Okay. So it's important to read the agreement. And we're going to cover it here. I think it's a pretty good fair shake on what the reading looks like. So here are the terms. And this is your header for your the top of the page as we get into paragraph number 2, right? Remember, this is paragraph number 2, terms of representation. And we're going to talk about number A1, which is what is the period. And so the concept here is you have to have, excuse me, by DRE regulation, by law, you have to have a beginning and an ending date. When I see people get in trouble, it's when they have maybe sometimes the beginning date, sometimes no ending date. And I've asked brokers, why did you do that? And they said, well, because we wanted to be able to modify it anytime we wanted to modify it. Well, if you're modifying a document over a signature or an initial, you're creating fraud, right? The Department of Real Estate's really clear about that. They love the word fraud because if they get you with fraud, you're cooked. Okay. So fraud means you deceive someone or you altered a document. So you never want to alter a document over an initial or signature. Okay. So beginning on a date certain, not like the silliness you see in the RPA that says, days, 30 days, 60 days. The law doesn't like that. Law wants you to tell them what date. So that's why this says beginning on what date and ending at a time, 11:59, the end of the day on this subsequent date. Okay, so, and again, we've already talked about how little you can have it, but let's talk about how long you can have it, or upon completion of a resulting transaction, whichever occurs first. So in parentheses, in bold print, not to exceed 3 months. End of story. Not to exceed 3 months. I see people trying to do it, and it's like, they create extensions instead, things like that. But the original document cannot be for more than 3 months. Okay. All right. Question. You're loving the Q&A field here. Maximum 90 days. That is correct. So Julie's question is, how long? It's 3 months. And I agree with Julie. I think we should have said 90 days. And I know CAR has been changing their forms. And I know that DRE is also watching what we're doing and changing their positions on these as well. If it is a natural person, not more than 3 months, if it's a corporation, LLC, or partnership, then it doesn't have to be that, right? Unless, so it can be longer. All right. So the representation period exceeds 3 months and the buyer is not an entity, then this agreement is void. And I hate to get into a conversation about what void means, but void means it never existed in the first place. All right. You definitely don't want that. Why? Because if a contract is ruled void, then the legal system puts the buyer and the seller back, or I'm sorry, the buyer and the agent back into the position that they were in before they ever signed the agreement. And so, that creates all kinds of havoc with deposits and things like that. So that's why we don't want a contract to be held to be void. Voidable means one party will have the ability to void it, the other one will not. but the law here says it's just plain void. It doesn't exist. Okay. And so void, voidable, valid, invalid, those are terms of law. Okay. All right. Type of representation, again, non-exclusive is the default language. So if you're not comfortable getting these things signed, then you might start out with that. I think you'll get over that pretty quickly. I mean, how many phone calls do I get from people where, I've been showing these people property for 6 months and they walked into a new home subdivision and the new home, I had an attorney call me who's a practicing broker and say that his client walked into into a new home subdivision and signed the name, Daffy Duck or something on the form. And then the next day he accompanied them on the next day. And the salesperson was there, said, "You're not getting paid. You were not here yesterday." And they were here yesterday. And they signed their name as Daffy Duck. And so, I know who they are. You're not getting paid. So, be aware of that. You've got to be present. But non-exclusive versus exclusive. If we have an exclusive agreement, which means you must work with me, and I agree to work with you, then it's valid only if this box is checked, and then later initialed and then the buyer initials later in paragraph number 15. Okay, everybody good? Question? You're asking good questions today. Thank you. Linda, so to confirm, and sorry I missed, but a buyer representation form needs to be completed prior to showing property and or working with a client. Is that correct? So NAR rules versus DRE rules. So NAR rule says before working with a client and whether showing them property either physically or virtually. DRE says as soon as practicable, so as soon as you can get to doing it. I think that I know that they're redefining that language. They now, instead of changing the language of the law, they're now going to create a definition for what as soon as practicable means, right? I think we created that word, but bottom line is the DRE is going to do that. So, but for you, if you're a realtor member, you must have a buyer representation agreement clearly before you show property, whether physically or virtually. I would recommend that you have it done at the first meeting. Some agents like to do 2 appointment closes. The problem is if you show them property on the first appointment and you don't have the agreement, you're in violation of the NAR Code of Ethics at a minimum. And then we'll have to deal with the DRE after that. Okay, good question. Thank you, Linda. Good question. All right, everybody good so far? Next heading, property be acquired, and the broker, including anybody working with or through the broker. Remember, the broker is the broker of your company. You could be a broker associate. You could be a broker license, broker associate, essentially is what we call them in California. Thank you, Linda. So provide services for the type of properties that are specified by the buyer below. And so what are my property types? Most people leave this alone, but single family residential, that's normally what you're going to be related with, right? Now, remember, we do have a separate agreement for tenant representation, okay? And I know a lot of people say tenant representation. Well, yeah, you have to have an agreement. You don't have to have an agreement. I don't think that's in the law yet, but it's coming. But, tenant representation is going to require agreement as well. I don't know. I do a lot of rentals and I find that people are willing to pay me to help them find something. So again, talk to your broker about that. But we do have a tenant representation and broker compensation agreement as well. So in this form here, or if checked, we're going to exclude some stuff. So I don't know why you would do that. I would probably leave it alone, right? I'd probably say single family residential, and then the parentheses ends after excluding it, so the opposite of, right? And then you have condominiums and manufactured homes, and then you also have other types of properties. Okay, all right. So location, where is it located? Now, I've always said, and it's very important, I've always said that you got to put in a location. You can't put in California, right? Even though my argument with the Department of Real Estate, and I was okay losing the argument, was that your license says California, so you could do it anywhere you want to do it, right? But we want to narrow that down. I always held a position 5 zip codes at the most, right? Narrow it down. The more narrow that you make it, the more likely it is to be enforced at law. Okay, and so the first part of that says, if I put in 92014, then that's going to be pretty enforceable, right? So as far as the zip code, County San Diego, I have a problem with that because it's too big. It's what we call law, we call it overbroad or overreaching. And then the city, could be Del Mar, could be La Jolla, could be a combination of those. Okay, but just remember, you got to have something in there. If you don't have anything in there at all, then again, you are too broad. You might have a problem enforcing the agreement. And remember, by the way, the enforcement of the agreement, it belongs to your broker, not to you. Okay, so all right, good. 6, did I get all the questions? Good, okay. All right. Additional description, if anything, if you've got something that you think needs to be added to the equation, you would put that in there. Can we include multiple counties and cities? Certainly you can. Again, if we're going to be covering a geographical area that's too big, then that might not work for you. Now, here's the other thing. Here's your risk. Let's say you say Del Mar and La Jolla, and then the buyer buys a property in Carmel Valley. I mean, now you're going to have a big fight over whether or not Carmel Valley is part of Del Mar. But for the most part, if you take the risk that if you don't define, you haven't had a good buyer consultation with your buyer, you take the risk that your buyer buys outside of the area that you have designated by contract. Okay. And so I think for me personally, I start showing them property, doing things like that. They decide whether they love me or not. If they want to go to another county or another city, they're usually calling me up and saying, let's just amend the agreement. And we just created an amendment to the agreement. Okay. Not an addendum. An addendum adds to things. An amendment changes things. Okay, is that good? Marjorie, what if the client is not 100% yet where they want to move to? Okay, well, all right. So that's a great question, actually, Marjorie. So let's say I always tell them this. I say, well, I'll tell you what. I know you want to buy a house. So let's start today. In the MLS, there are 37,000 listings. If we start today, we might show them all. We might get a chance to see all of them before the end of the year. Highly unlikely. Most people, if they don't know where they want to move to, then why are they moving? Do they just want to get out of where they are? So that would start the questions of what is it about where you're living is not making you happy? What do you envision the place where you want to move to that would make you happy? And so those are good questions to ask them. So Marjorie, thank you for that. Location is the city only, not a particular address. Oh, sure. Yeah, Julie asks a good question. Could you put in a particular address? Sure. 1, 2, 3, 4, Camino del Mar. You could do that, right? You could put in a specific address. That's for sure going to be narrow, isn't it? It's not going to be too broad or overreaching. Okay, good question. Thank you, Julie. All right. Additional buyer preferences and priorities. And I'm a little worried I'm going to run out of time. So we have these forms. I have them available to show you. I'll just show you that I actually have them available to give you a peek of them, but let me got to move some things around here. So here's my buyer identification of preferences and priorities. So I have all the forms pulled up. Again, I want to make sure you're using the current versions of the forms. So I'm not going to spend a lot of time on those because I don't think that that's a detail that we really need to cover at this moment. Okay, so got that. Okay, so anyway, that's the form. So let me go ahead and get back to our presentation, moving along here. And again, they would tell you what they wanted to do differently. You could put it on that page. Properties excluded from representation, for example, they saw it with another brokerage or they're working with a for sale by owner or something, they put the addresses in here. Excuse me. Broker compensation, my favorite subject. Remember, not commissions, compensation. Okay, so broker compensation. Notice, and this is required by the Department of Real Estate that this be in your agreement. All right, so the amount or rate, so amount would be a dollar figure, the rate would be a percentage of sales price of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between buyer and broker. I always emphasize may, and they go, why'd you emphasize may? I go, because it could be, I'm just a terrible negotiator and you want me to work with you. So do you want me to be a lousy negotiator or a good negotiator? And so if you want me to be a good negotiator, you understand why I don't negotiate. I'll negotiate on your behalf. I'll probably do a really good job of that. I think you can figure that out right away, but I get what I get, whatever that figure is. Okay. So see attached broker compensation advisory. Again, pull that form, always pull up the current version of the form. Okay. All right. Amount of compensation. So let's talk about that. Again, compensation, not commission. So how much is that going to be? It's either a percentage of sales price, the purchase acquisition price, the rate, and if any, some dollar figure. I don't know what you would put in there. And here's why I say that, because I was in a meeting with the district manager for the Department of Real Estate back in October of 2018. And she made a comment. She said, agents were putting in TC fees and things like that. And the DRE says, if you're going to put in a fee, you got to put in a dollar amount so people know what it is. And the district manager's comment was, we think that the agent should be paying the TC because the TC is doing some of the work that the agent is required to do anyway in the transaction. Now, mind you, there are regulations coming with transaction coordinators. I'm telling you this ahead of time, but there's going to be, I think, maybe even some legislation. But I find in my experience, a lot of times in my work with TCs, I get legal advice from them and stuff like that, and it's just not going to work. So back to our form here. Let me make sure I'm still in the form, that I haven't lost yet. Okay, good. So based on my form here, I can charge a percentage of acquisition price, or I can charge a dollar amount, or my broker might have a broker created compensation schedule. Frankly, I've never seen one. I don't know. I mean, maybe it would say, up to $1 million, I charge, 10%, up to $2 million, from $1 million to 2 million, I charge 20%, whatever, those kinds of things would be. Okay. Everybody good? Okay. Whoops, chat. Okay, hang on, I got a chat. How do we write in an upfront retainer for services in BRBC? You just go into your Zip Forms program and type up, upfront retainer? No, okay, hold on, thank you. So remember, the Department of Real Estate says you may not collect an advance fee. So you cannot collect a fee in advance of doing the work. That's going to be a legal violation. So I'm sorry, Adam, now I understand your question a little bit better, but an advance fee is against the law. For us as real estate agents, okay? Attorneys charge retainers, but even my expert witness work, I don't call it a retainer agreement. I call it a consultation agreement. But I would tell you to be careful about getting dicey with the law. Talk to your broker about it. But I do not charge an upfront fee. I will not charge an upfront fee. Okay, all right. Question. Hopefully, I answered your question. Linda says, you mentioned the seller is responsible to pay the listing agent. The seller could be responsible to pay the seller's agent, correct? And the buyer is responsible to pay the buyer's agent. Yes. If the buyer's agent is going to receive compensation, it comes from the buyer's agent. I'm sorry, from the buyer, unless the seller is willing to compensate the buyer's obligation to pay their agent. And I'm, again, being very careful how I'm saying things, right? So if the buyer is got a buyer representation agreement that says, I'm paying my agent, let's just say 3%, for argument, I'm paying my agent 3%, the buyer can ask the seller to pay that obligation of the buyer to pay the buyer's agent, okay? So that's why it's okay to put it in the purchase agreement, put it in the purchase agreement, put it in the counter offer. Everybody good with that? It's a great nuance of law. I called Carr Legal and I said, all right, let's go through this. And so we went through it and we're like, you know what you're saying makes a lot of sense, but that's why it shows up in the counter offer, is because the buyer and the seller can negotiate how much they are going to agree to pay the buyer's broker. Now there's going to be other issues, right? So if the buyer doesn't get the money that the buyer's broker has agreed to accept, the buyer may be on the hook for the difference, okay? So let me see if I'm answering the rest of your question. I recently did 2 deals and my compensation did not come from the buyer. I'm guessing there's more there that you're aware and can help explain. My compensation did not come from the buyer. So remember, the Department of Real Estate's position is whatever you have in your buyer representation agreement, you may not receive more than that from any source. Those are the rules. Not more than that from any source. So be very careful about that. And so, Linda, I'm not understanding your hypothetical. Again, I'm assuming it's a hypothetical, but if you got compensation from someone else, you still had to have an agreement with the buyer if it was the buyer that you were representing. Okay. Adam says, how do we handle a client with endless viewings over a 3-month period? I think you should fire them. No, I'm just kidding. I mean, and a lot of times we get in, I've done this much work on it already. I don't want to lose, what I've done. Sometimes, if your buyer hasn't bought a property, and again, I get it. People keep telling me the market has changed now. It's a buyer's market. I'm not seeing it. I'm still seeing 5 offers on a property. I'm still seeing things like that. But how do you make sure you're going to get paid? And those are, I think that has as a result of what your buyer consultation looks like. And again, I think you should sit down with a buyer, find out what their motivation is to buy, right? So just like you do with a seller, motivation to sell, right? But if your buyer says, we're just looking around, we're just kicking the tires, we're really not going to do anything, then I think that's a clue that maybe you should consider, doing something different. But so yeah, I'm with you. I've shown property. I had a business partner. We showed probably 46 properties, wrote 10 offers, and every time we would write the offer, the husband would come back into town and cancel it and say, I don't want to buy that house. And so it was just, we realized after a while that the husband didn't want to move. And so, that was when we decided to exit the relationship with the client. Okay. Can we get paid per week or per hour? No. If you're an attorney, you can, right? So just like you are paid at consummation of a sale, attorneys cannot receive a percentage of sales price unless they're also a broker. And this just came up in a meeting I had with the commissioner last week. The attorneys are not allowed to do real estate transactions except under a retainer, except upfront fees, except hourly. They cannot do what we do, which is receive a percentage of sales price. So great question. Thank you for that, Adam. Hopefully I've answered it. If not, hit me with it again. I got people coming in my driveway. I don't know what that's all about. So good. Payments received by broker from seller or others. I just talked about this. So if the broker receives compensation from the seller or others for broker's representation of the buyer, the amount shall be credited against the buyer's obligation to pay the broker. So if your agreement says 3% and the seller says, I'm only paying you 2.5%, then the buyer owes you 0.5%, right? So, I just had a phone call the other day. The agent said, I have a buyer representation agreement for 2.5%. And then I called the seller's agent who says, oh no, we're willing to pay you 3%. And so the agent said, what do I do? And I said, well, you're going to need to amend that agreement as quickly as possible, right? Because you certainly don't want to amend it after you find out what your commissions are, if you've already created a purchase agreement. So they ended up amending their buyer representation agreement to match the fact of what the seller's agent said the seller was willing to pay. I recommend you have those phone calls up front. I'd probably talk to them up front, but again, check with your broker about that. Okay, so again, it is credited towards the buyer's obligation to pay their broker. All right, question. Thank you. You're all asking good questions. Linda, where in the offer do I negotiate the seller pay the buyer's agent? That's going to be in paragraph 3G3 of the purchase agreement. Thank you for asking a question I happen to know the answer to because I address that paragraph a lot. I'm not sure if you saw my last question above. Yeah, I just saw it. Okay, 222. Yes, thank you, Linda. But 3G3, I think we're going to be changing that paragraph, but for not until December. So for right now, write your offer. And in that 3G3, you put in seller to pay the buyer because it's the buyer giving you the instruction to have the seller compensate you. So if you're the buyer's agent and the buyer signed an agreement with you that says 5%, and then the buyer instructs you to ask the seller to pay 3 of it, then that's what you put in there. But that's the purpose behind that paragraph. Okay, everybody good? Broker shall not receive, and I just said this a minute ago, broker shall not receive any amount in excess of the amount in 2E1, which was our commissions. Is everybody good with that? So don't get cute on this because this is a license losing opportunity, as we say. So don't get cute. Collect only, and I don't care what else you call it because what did the Department of Real Estate say? Commissions are right. They are set by each broker individually. Oh, that's interesting. They don't have the form the part that says in the listing agreement, but that includes all compensation to the broker. Interesting. Okay, so I just noticed that. All right. Oops, where am I going? I'm going the wrong way. 12 years of college down the tubes. Okay, cancellation. I'm going to skip some of the forms. Question. I'm going to skip some of the forms. You can look the forms up. Can I ask the listing agent if the seller is willing to pay buyer agent compensation? Sure. They just can't publish it anywhere in an MLS. They can put it on their website. They can do that. They just may not put it in the MLS. Okay. All right. Good question. Okay. So we covered that paragraph. So again, questions, please keep them coming, folks, because this tends to be the part that confuses people, and we want to make sure we do it the right way. We're not looking to take advantage of anybody. Okay. Continue to write to payment for broker-involved properties. A broker-involved properties means a property that you introduce them to, again, whether physically or virtually. What if I check B1 accidentally for SFR? Then you would be exempting SFR from this agreement. So I probably think about whether or not that's your intention. Continuation period used to be the safety clause or the protection clause. Remember that was actually a question on the state exam, and hopefully you got that one right. Linda, so interesting. So as the listing agent, seller's agent, we don't call him listing agent, with the new settlement, how would you go about explaining that offering compensation to the buyer's agent would be a good idea? So if you're talking to the seller, you say that, well, the seller's no longer has an obligation to pay the buyer's agent. And so that means the seller sees maybe a different commission structure on their agreement, because there's nothing in the listing agreement. Linda, great question. Nothing in the listing agreement that obligates the seller to pay the buyer's broker. Okay. The buyer's broker can always ask, the buyer can always ask by contract, but there is no obligation for the seller to pay the buyer's agent's compensation. Okay. All right. Good question. Great question. All right. So you put in whatever period of time you want that to be, 30, 60, 90, 10, 5, whatever. If you don't put something in there, the courts have held that you didn't care. And so then your commission is not protected if they turn around the day after you showed them a property and buy that property. So you definitely want to put something in there. I would advise, right? Wink, wink. Cancellation. Of course, we never want to talk about cancellation, but in a non-exclusive contract, which means they can go anywhere they want to go, it's upon receipt. Or if it's an exclusive, then they're going to give you 30 days. Okay. All right. No, keep the questions coming. This is great. Linda again. Do you see that it's still typical for sellers to pay the buyer's agent? I'm seeing it happen in transactions I'm involved in, that the seller's been paying the buyer's agent. But again, no guarantee. I am seeing various commissions. I'm seeing situations where the seller has said, I'm only going to pay you a point or 2 points or whatever. And remember, if the seller falls short of what the buyer's obligation to their broker is, the buyer has to make up the difference in that. And the buyer is going to use that in their decision whether or not to move forward with the transaction, because that's going to become a closing cost for the buyer. It's going to be a cost that they're going to be having to pay. And remember, we've changed the rules at the VA as well that says that the buyer can pay the buyer broker compensation, whereas it never used to be that way. There was a restricted cost. Okay, buyer's financial personal information. I disagree with CAR on this, but okay, within 5 days by default, the buyer has to deliver personal financial information. Talk to your broker about that. I personally don't want that in my file. I don't collect social security numbers, don't collect things like that. Lender does loans, escrow does escrow, title does title. I have the lender have all that information. Okay. Buyer does not have sufficient funds to pay the broker. The buyer tells you up front, I can't afford you. You get to make a decision moving forward. If you find a seller that won't pay you, and you're not going to interfere with the contract between the buyer and the seller, then you may not be compensated in the real estate transaction. Other terms, whatever those might be, advisories, addenda, and disclosures. And I'm just checking up here, make sure I'm getting everybody's questions. I got everybody? Good. And Linda, your question was even better, because you said, do you find that it's still the case that sellers are paying buyers, brokers, commissions? And I'm going to tell you that it is, I'm seeing it personally, but I don't know that that's an industry standard. I think NAR publishes statistics on that to say that, yes, it is, because it's the way the sellers always knew to do it. But, I always tell my seller when I take a listing to factor in the possibility that you may be paying the other agent, the other broker at least. Okay, advisories, addenda, and disclosures. So the following advisories and blah, blah, blah. Broker compensation advisories included by default. It's attached to your form as part of the template, okay? Compensation to the broker, here we go again. Same language we saw a few minutes ago. There. Now I have in A, real estate commissions include all compensation and fees to the broker and are fully negotiable. Okay, you don't ever want to tell anybody that it's required by law. You could tell them it's our office policy, but you cannot, and check with your broker on that, because your broker may say, no, we don't want you saying that either. But that's one of the reasons why your compensation is not filled in advance by CAR, because then that would imply a statewide standard. So they don't fill that information in ahead of time, right? So when you go to write your buyer representation agreement, just like your listing agreement, you then put that in the field. Okay, everybody good with that? Important concept. Broker's right to compensation. If during the representation period or an extension, the buyer enters into agreement to purchase, etc., and the seller thereafter completes the transaction or is prevented from doing so by default of the buyer, right? That's a possibility. So in what happens in non-exclusive representation, broker involvement, compensation is payable only if there was broker involvement with the property. Exclusive representation, buyer acquisition, if exclusive is checked, then and initialed in paragraph 15, which we're going to see in a second, broker is entitled to compensation if the buyer acquires the property or during an extension or with or without broker involvement, even if another broker is also entitled to be paid for representing the buyer. So that's why we always ask the question at the open house, for example, do you have a buyer representation agreement with another broker, right? NAR changed its code of ethics in January of 2008, requiring that you ask that question, one of the first questions you ask the buyer when they come into your open house, okay? What's a buyer? And this explains some of the stuff that I've already talked about. It could be somebody acting on behalf of the buyer. Broker involvement, what does that mean? Buyer physically entered and was shown the property by the broker, and the broker showed the property to the buyer virtually. That is protection. Now, so question, I'm waiting for it to happen on the screen here, but the question is, what if I send them a list? What if I just have them on an automatic drip system, which I never use those words because I think it's like a disease. But what happens if I send them that information? You are not going to be protected by that. Okay, they very specifically have stated that that does not count. You've got to but you can get them on the phone and just start talking to them about a particular property, take notes and do stuff like that. Then you're more likely to get it enforced. But if you're just sending them a list that's an automatic system, probably not going to be entitled to compensation. Buyers submitted to the agent. This is going to be my procuring cause paragraph. Broker performed a market analysis, right, or reviewed property-specific documents or disclosures with the buyer. These are things that you want to document, date and time that you had your call, whatever. You talk to the client about it. Obviously, email is really good because it documents it for you. The property was introduced to the buyer by the broker or somebody else operating on the broker's behalf. However, merely sending a list of properties shall not be deemed broker involvement without documented action on the part of the broker. So you see, I'm reading ahead and seeing that what these things are going to say. Okay. Question: when I take a listing and seller agrees to pay 5% total, that 5% goes to you. Do I have a choice to keep it all or share 2% to the buyer's agent? No. When the seller signs an agreement with you to pay you 5%, the seller owes you 5%. If the buyer comes along and says, and I get this all the time, buyer comes along and says, will the seller give me 2%? Will they give me 3%? Whatever. Your listing agreement will not have that figure in it. So you're listing a figure. If you have 5% in there, you as the seller's agent are getting 5%. And if the buyer comes along and makes an offer on your property and says, will you give me 2% of whatever you're getting, then I would have a writing with the seller that says, I'm going to give the buyer 2% of the money you're giving with me. And so I think it's kind of counter to what the intention was when we changed the RLA. Okay, so be careful about that. All right. Good question. Okay. This paragraph's a good paragraph. Tells you all the stuff that's going to entitle you to compensation. Continuation of right to compensation for broker-involved properties. And again, if during the extension, the continuation period, as we call it, broker's right to compensation If prior to expiration of this agreement or any extension, broker delivers buyer a written notice of those properties. So that's what we call our notice of broker involved properties form. And that's again, in case your agreement is expiring, or if you just want to protect yourself, I would probably do that. Timing of compensation. Compensation is payable upon completion of a transaction, obviously, and through escrow. Broker shall be entitled to compensation whether any escrow resulting from the transaction closes during or after the representation period. So if you're under contract with a buyer, between a buyer and a seller, and do you need to extend your buyer representation agreement? The answer is no. It just needed to happen during the representation time period in order to apply. If acquisition is prevented by default of the buyer, oops, question, hang on a second, because this is going to be important. Let's see here, or can I keep all 5% for myself? Yeah, if your seller agrees to pay you 5%, you can keep the 5%, right? Well, your broker gets the 5%, but again, you're probably, I mean, I don't know, you do whatever your contract says, whatever your broker tells you to do. I think if the buyer's agent, there is no obligation for the seller to pay the buyer's agent. So if you put yourself in a position where the seller says, well, give them part of yours, you can say no, but you also probably not going to get the deal put together, but those are other issues. Transactions, I've continued to have seen the sellers still paying the buyer's agent. Well, again, we talked about that. Do you foresee at some point more sellers not wanting to pay the buyer's agent? Oh, certainly. Remember when a seller sells a property, they look at their cost of sale, right? So, that's going to be, how much they're paying their agent, how much other expenses might be, right? Where does that leave the buyer's agent? Well, I don't know. I'm not seeing sellers not paying it, but where it leaves the buyer and the buyer's agent is the buyer pays it. And frankly, I think that's the way it should be, is that the buyer pays the compensation to their agent, right? You hired them, you pay them, right? Now, again, I get the whole argument about, well, they don't have any money and all that. I get that, I understand it. But again, you don't sign the contract or tell the agent with that checkbox that says, I don't have the money. Okay. If acquisition is prevented by default of the buyer upon the buyer's default, then somebody other than the buyer, and the buyer succeeds in a lawsuit, you are entitled to portion of that money, right? So if they recover money, you're entitled to half of the damages recovered, not to exceed the compensation in the form after first deducting the unreimbursed payments. Okay. All right. Speeding it along a little bit here. Payment through escrow. Obviously, it's you irrevocably assign to the broker instructions to pay you. Again, accounting for payments by others, payments received from others for broker's compensation. So it says here it would be beneficial to include a term that that the seller would pay the buyer's compensation. And again, that is currently in our agreement, paragraph 3G3. If the seller does not pay as contractually required, then the buyer now assigns to the broker as a TPB, a third party beneficiary, any rights the buyer has to pursue the seller for that compensation. Okay, so I'm getting a whole bunch of questions now. All right, so hang on. So do you think that it's better to keep 9B2 blank? I don't like blank lines. Just it's a law thing. Never leave a line blank. With the cost of living in young families barely having enough, oh please, you're buying a house, and down payment is going to be interested to see how this shifts the agent relationship. Well, I'm seeing no real change. And again, we've been doing this now for over a year and a month, and I'm not seeing any impact on our market. And I'm seeing buyers pay their brokers compensation, and I'm seeing buyers getting sellers to pay their obligation to pay their broker's compensation. I'm seeing all of that. We work all that out because it's all numbers, right? And so I understand if somebody doesn't have the money to put down on a property, then they may not be able to buy a property, period, right? And so, and I'm sympathetic to that because I believe our job is to help the homeless. All right. Okay. I got to hurry this one along. Under the settlement agreement, brokers prohibited from receiving compensation excess of the amount in this agreement, as we've talked about already. And we disclose the payments that we make. Cancellation of the agreement. And again, remember, these were the items in paragraph number 2 that now we're explaining later. Okay. So again, notice requirements for cancellation. Buyer shall be entitled to compensation during representation period, blah, blah, blah. Buyers advised to notify any other broker of the buyer's rights under this paragraph. Agency relationships, we're just going to confirm that we are in single agency at this point, but then there's also potential for dual agency. So your PRBS form gets the parties to agree to allow you to be a dual agent if it becomes that in the transaction. Property is excluded from representation. And so what happens if the buyer decides to write multiple buyer representation agreements? I would recommend against that. But the buyer needs to tell the broker that they're doing that. And again, they could be putting themselves in a bad position. And so it's up to the broker to explain that to them. Buyer shall disclose to the broker if another broker has showed the buyer property, whether virtually or in person, et cetera. Sometimes we get into a point where we are, committing our buyer to pay 3 compensations. And so that creates a real problem for us. And so even though it's the buyer, sorry about that, I got a dog going off in the other room. But it creates a challenge for us. So, don't think you're going to blindside the buyer into getting into a bad situation. So buyer shall disclose in 2D any property for which the buyer is obligated to pay another broker, and then conflicts with the other broker. So this paragraph addresses that. Has not entered into exclusive representation agreement. I mean, if they lie to you, they lie to you, and people do. And sometimes people don't don't know what they've signed. Okay, so I'm going to speed this up. Limitation on broker representation. I'm only going to do what I say I'm going to do. And then this paragraph 8 is very important. Brokers' obligations and authorizations. I agree to use reasonable effort and due diligence to achieve the purposes of this agreement. Broker will assist the buyer by locating property, et cetera, et cetera. I like this part. I write this part out. I make the lawyers in my class write it out. And then that way they've memorialized that this is what we're going to do. If you define your duty, you limit your liability. We'll talk a little bit about that later. And so we'll provide you with a list of people that will do services for you, but we're not going to guarantee any of them. And then again, here's my obligation under paragraph C. If it's a residential 1 to 4, then we know that California Civil Code governs. If it's a 5 or more, then it's Uniform Commercial Code, reasonably competent, diligent visual inspection of the accessible areas of the property. So that's good. Broker services are performed in compliance, obviously, with federal, state, and local anti-discrimination laws. What does the buyer have to do? I had this conversation with one of our previous commissioners who said, oh, yeah, I like the fact you make the people write this all out. Good faith. What's the buyer's obligation? Good faith. They agree to be honest with you. They agree to act in good faith. Financial, personal information. If they're going to give it to you, they're going to give it to you in a period of time. They agree to include a term in the offer asking for compensation. They understand the fact that it's not automatic, that they are obligated to pay it if they don't ask for somebody else to pay it. And again, remember that checkbox that says that the buyer doesn't have any money. Okay, reasonable care and other professional assistance. So the buyer is obligated and agrees to read all the documents. Wow, there's a surprise. I have court cases on this. I mean, I have trial that I'm involved in where, the buyer says, well, I didn't read it. It's like, well, you said you would, right? Okay. So get assistance from appropriate professionals, read the buyer's investigation advisory. You agree to go to meetings that we create for you on your behalf. Buyer material issues, use this form, folks. I rarely ever see it used, but it says, the buyer says to you, these are important things for me in consideration of what I want to buy in a property. If they tell you schools are important, remember, you don't represent schools, all right? So, send them the websites, whatever. But I would not get into quoting school information, right? Except from a government agency or somebody that does that as a matter of, course, that's publicly accessible information. So if buyer tells you untruths or things like that, they agree to defend you. Attorney's fees. So again, each side is responsible to pay their own attorney's fees. And that's a departure from the old agreements, which used to say that prevailing party gets their fees. Now we're just going to make it so everybody pays their own, which makes it so that plaintiffs don't, hire $850 an hour attorneys and move the bills up. Remember that your agreement is not binding on the brokerage unless the broker signs it. That's why you've got 3 days by DRE rule to get it to them. Dispute resolution, we're going to talk about mediation first always, but you could do additional mediation terms. So obviously small claims court doesn't apply. And then we have an ARB form, which says if you want arbitration to apply, you can do that, but you're going to have a separate form for that, okay? We took it out of the listing agreements essentially because most of the brokers were saying, I don't want to be bound by that. I want to go to court. Legally authorized signer, so the buyer is telling you that they are either the signer or have authority to act on that capacity. This is the entire agreement, the whole agreement. And again, I'm doing a 3-hour class in 2 hours, so I apologize. But this is the entire agreement between the parties, no parole evidence and stuff. If exclusive is checked, and that's going to be down here, you're not going to enter into another agreement with somebody else. And so here's what the compensation looks like. And there's the initial part at the bottom. This is paragraph number 15, okay? Now, by signing below, you've agreed to receive a copy of this, and then entity buyers, you're going to tell us who you are. And that's what this is all about here. If you fill this information under parties up the top as zip forms, it'll populate properly for you. And if you have trouble with that, let me know. I will help you with that because it populates your forms properly, but you got to fill it in properly up under parties. Okay. Contractual identity of the buyer, et cetera, and then legally who's authorized to sign on behalf of that entity, and then buyer signatures again. And this is all fast forward because it's the same stuff. Broker signatures, there you go. And we could have more than one agent from the same firm. We'll have that AAA form. And then we also have the additional broker acknowledgement and I don't see this happen very frequently where more than one broker represents the buyer. They need to have an agreement between themselves, but I rarely ever see this. All right. That's the form. Do you feel better now? I mean, I know we went a little faster as we got going, but how do you all do? Are you doing okay with this so far? I'm going to tell you a couple of other little things here. And Linda, by the way, I'm not insensitive to, young families and people trying to, buy houses, but I'm finding more and more cash nowadays than I've ever seen. 38% of our buyers were all cash, when the market supposedly went sideways. Remember that when you define your duty, you limit your liability. And so again, that came from Wayne Bell, who was the commissioner of real estate. And he said that very same thing. He said, define your duty. And that's in that buyer representation form. Because what was happening, they were coming to us and they were saying, well, you didn't do this. You didn't have the utilities turned on in my name. Nowhere in there under broker obligations does it say, I'm going to put the utilities in your name. Okay, so if you tell everybody in writing what you're going to do instead of just waiting for the potential lawsuit, then they're limiting their ability to recover from you or from your broker. Okay, feedback, suggestions. Please let OCAR know. I mean, I can't believe I'm gonna get this done in 2 hours, but anyway, please let OCAR know. I want to support you being a professional, real estate professional. And so my experience has been ask a lot of questions. You can always send me questions afterward. Go to my YouTube website. Here you go. Here's your QR code reader. That'll take you to the YouTube website. Or you can just type in @Burke Real Estate Consultants, Inc. I do a lot of videos up there. I've got quite a few subscribers. Question. Thank you, Elia. Thank you, Linda. These young families are also pretty tech savvy. Oh yeah. So I wonder how many of them over the next 5 years would not see it necessary to hire a buyer's agent. I've never worried about that. Your question's a good one, Linda. I go back to Brad Inman at the 2001 Inman conference that I attended, where he told everybody that we are compressing commissions downward. We see the day of the salaried real estate agent. And it's like, really? And then the next year he shows back up and he says, I'm wearing a black suit because I just came from the funeral for the .coms. So thank you, Sherry. You're very kind. Thank you. But literally, don't worry about what other people are doing. Don't worry about all the threats. Get good at what you do. Be good at this. Learn new things every day. My first 5 years in real estate, I went to everything I could, especially OCAR. They're giving you all this for free. Go to all this stuff. It's free stuff, folks. Suck it all in. 5 years, I did nothing but go to these things. And of course, I'm selling houses, and people were calling me up saying, "How are you selling all these houses?" And I thought, God, I thought everybody did this. I didn't know any better. I was brand new, right? But I knew enough to learn new things. Get good at what you do. And I assure you, Chica Sundquist, the commissioner of real estate, agrees with me on that. Learn new things every day. You can't know everything. You don't have to be a lawyer to be good in real estate, but learn something new every day. Rick says, can the buyer's broker use an addendum to amend the compensation owed in the BRBC? I'm going to get kicked off. In the event the deal can't afford the compensation, you can always do an amendment. Okay, here we go. Very good. Elsie's putting in the chat for any legal questions, please go to these people. I agree with Elsie 100%. Like and subscribe if you wouldn't mind. Thank you again. I do have a newsletter that goes out once a week. Send me an email. It's opt-in only. Send me an email. I'm more than happy to put you on it. And if you don't like it, I'll take you off of it. But I put a lot of quotes in there from the Department of Real Estate. I go through all their stuff right before I send it out. So thank you again, Orange County Association of Realtors. You're awesome. Thank you all for being here to learn something new every day, and let me know how I can help you, please. Thank you all. Have a great day.